Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday at 10 a.m. Pacific time here on the Bottled Business Sense Show. I want to welcome everyone here to today's episode. I'm Rick Moscoso, one of your co-hosts today. And Bill Bernard, my other co-host, is on the other side. And you can probably surmise where he's at, which office he's at based on the shirt that he's wearing. But I'll bring him on in a second. We are a simulcast show really tailored to the business owner. And we offer up free legal tips, best practices, some advice, as well as best practices for your marketing and video marketing portion of your business. And so we do this for free because we're really passionate about providing information to our listeners to help them be prosperous and also be protected at the same time. So with that being said, hopefully you've been watching us for quite some time. If you're new to the show, we are on, you can find previous episodes on Blog Talk. I'm sorry, not Blog Talk. Well, yeah, you can go to blogtalkradio.com and find us at Bottle Business Sense Show, or you can go to bottlebusinesssenseshow.com and take a look at our many episodes that we've done over the last several years. If you happen to miss some, or if there's something there of interest for you, there's something of interest for everyone out there. So take a look at it. There's a wealth of information that we've shared with our listeners in the past, and feel free to reach out to us if you would like to hear a future episode or even want to be a guest on the show. We certainly welcome you to do that. So send us your inquiries to bottlebusinesssenseshow@gmail.com. So welcome, everyone. Today, we are talking about a legal topic, but before I ruin it for Mr. Bill, I'm going to bring him onto the show to let him tell us a little bit about what we're going to be speaking about today.
Yeah.
So how you doing today, Bill?
Good morning, Rick. I'm doing great. Thanks. We've had a show before that dealt with the ADA, which is the Americans with Disabilities Act. California has a similar statute under the FEHA, which is the Fair Employment and Housing Act. And while we've gone into this before, we maybe have not addressed the interactive process that's involved for business owners when this happens. And this is a really hot button topic. I have several cases myself now dealing with this issue, and I know a number of other lawyers that do as well. And of course, our business owners are faced with this stuff all the time. So I thought it would be prudent to address both procedural and substantive aspects of what do you do when an employee advises you that they need some sort of an accommodation in their job because of some disability, either physical or mental, that they believe they're suffering from. And I think at the top of the show, we need to point out that there is a duty by the employer, some of our viewers here, to engage in the interactive process that may in fact take hours, days, months, or even longer to finally come to some resolution about. And a failure to engage in this process under the California statute is in and of itself a violation. So if somebody says to you, I need an accommodation, and you refuse to even engage in any process to determine if in fact they do need an accommodation, that is a cause of action that employee would have against the employer. So it's a standalone issue that needs to be realized by the employer. And And interactive requirements, when you're engaging with an employee, there's certain things that you're going to have to pay attention to. And these things really come into play in order to do what? To avoid a lawsuit, to avoid any kind of claim of discrimination liability while simultaneously enabling a disabled worker to remain productive on the job. So your two goals here is to get somebody who claims they're disabled to continue to be productive, and two, to avoid discrimination lawsuits. So you have something benefiting the employee, something benefiting the employer. That's why it's called an interactive process. So you got to do a couple of things here. You got to analyze the job to determine its purpose and function. You got to consult with the individual to determine what the claimed disability is. You've got to investigate potential accommodations and consider whether or not the accommodation can be implemented without damaging your business. So let's start with the procedural part of this, which says notice. The employer has notice of a disability and then has the obligation to enter the interactive process. Now remember, an employer can be charged with having knowledge of a disability before an employee ever comes to that employer and advises them of a disability. So what does that mean? It means you got to know what's going on in your business, right? I mean, if you don't know what your employees are doing and what their possible deficiencies are, you're not going to be able to spot this stuff, and you can't just depend upon them to come to you. Now, if they don't come to you, does it weaken their case somewhat? I would argue it does. But, this is the whole point of this, to have an obligation by the employer to enter into this interactive process and to initiate it where necessary.
So, Bill, give us an example. I mean, if you've done your due diligence through the interview process and you've hired this individual, this employee, and they don't disclose a disability, then how are you as the employer on the hook to? Well, you may. I mean, that's a pretty simple question to answer. Actually, it's if you observe something about their behavior that causes you to believe that they need to be looked at, then you need to initiate a conversation with them and say, "Hey, I've observed this. It's affected your work. Do you have a deficiency, either mentally or physically, that needs to be addressed?" Or maybe you actually see them doing something that shows a physical disability, as some sort of people exhibit when they have a disability. Then it's your obligation to engage with them and ask them to get checked out. If they refuse to do so, then you need to document all of that information in case it comes to some sort of disciplinary action and or termination later on down the line. You need to initiate that step, because that shows you're on the ball. That shows you're trying to do what's best for the employee and what's best for your business. And sometimes that's a very fine line to walk, as we all know. So what happens in the case that, okay, the employer does his due diligence. He notices some deficiency in their physical being or whatever it might be that would cause attention. And then he follows up with the employee and they deny anything's wrong. And then several months pass, and then all of a sudden, here comes this issue presented by the employee of something he just denied a couple months ago. Does that weaken his case in justifying?
Well, here's what I would do. I would provide an accommodation. I would say to the employee, you as an employee are required to provide me information about your educational qualifications and work experience, so I can find you a suitable position. You came into my company, I found you a suitable position. Now I don't believe your position is suitable for you because of what I've observed, which, by the way, you document and you do in front of a witness who's present with you with that employee. If the employee refuses to acknowledge it, you make the decision that you're going to have to change his or her job duties and find them a suitable alternative position. That would be my first choice. If that employee refuses that suitable alternative position, now you have a basis for termination, because that employee has refused to cooperate with you in the interactive process which he or she has an obligation to do, just like you do as the employer. If you come to that employee, you're showing that you're on the ball that as an employer, that you're looking out for your company and for this employee, and that requires the employee's cooperation. I mean, after all, you can't hold a gun to the person's head. Okay, so that's it. So now, if you've come to, let's say you have an interactive process where you're engaging with this employee, and again, as we just said, it's incumbent upon the employee to cooperate and provide you with information which would allow you to differentiate or evaluate another position for that employee. Now you're faced with okay, what is a reasonable accommodation? Both the American with Disabilities Act and FEHA under California require an individualized assessment of every employee's work restrictions. It doesn't specify, in other words, what is or is not in black or white a reasonable accommodation. You have to investigate on an ad hoc basis, that means on an individual basis, every particular employee's issue. So how do you do that? All I can do is provide you with guidelines. And I shouldn't say all I can do, it's important stuff. But you need to consult with your attorney, you need to document stuff, you need to be on the initiative. And if you're doing all those things, you minimize your chances for a disability claim. And if one comes down the road, you minimize your chances of losing in a lawsuit by doing these things. 1, make facilities readily accessible to disabled persons. Break rooms, whatever it is, restrooms, training rooms, reserved parking spaces, whatever. Be open to job restructuring. Offer part-time or modified work schedules. Reassign somebody to a vacant position that you may have. Acquire or modify equipment or devices that the employee uses. Provide qualified readers and interpreters for employees who may need that sort of thing. There are a lot of different things, including modifying various supervising methods that you can implement to help the employee. What's the bottom line here, Rick? You have to be proactive in determining whether or not you can provide a reasonable accommodation. Now, who decides what's reasonable? Well, employers have the final say in deciding what's reasonable. So that's why you've got to take this process seriously and do everything you can to implement these possible changes in the job, because ultimately you're going to make the decision. And once your decision is made, now the employee is faced with saying, great, thank you, or I'm going to sue you because you haven't accommodated me with a reasonable accommodation. So as long as the accommodation is reasonable and could plausibly enable a handicapped employee to adequately perform his or her job, the employer is not liable for a failure to attempt an accommodation. So let me repeat that. As long as a reasonable accommodation is available to the employer that could have plausibly enabled a handicapped employee to adequately perform his or her job, and that is offered to that employee, the employer is not liable for failing to attempt an accommodation. He or she is attempting to provide that reasonable accommodation to that employee by looking at all of those things I just mentioned in the job. So the final thing to look at here now is, when you look at all of these things and attempt to change a job for a disabled employee, when do you say that there is no reasonable accommodation available? In other words, when do you say, I've looked at all of these factors, I've examined the job thoroughly, I don't believe there can be a reasonable accommodation? what would you think the factors would be that you would have to consider to make that important decision? Because once you make it, if the employee's ticked off at you, you're going to get sued. But you got to do it and you got to document it. So what would you think, Rick, would be the things that you would have to look at to determine if, in fact, after an examination of all of the alternatives, an accommodation was not available? That is, an accommodation could not be found to be reasonable for that disabled employee.
Well,
some should jump. I'm putting you on the spot here, but some should jump right out at you.
Well, I mean, if there's not an accommodation for them and everything's been looked at, then I don't see any other choice other than saying here,
Yeah, but why
there's not a.
But why if you looked at all of these things, let's say that you've looked at all of these things and you were on the cusp of deciding whether or not you could make this accommodation. When would it not be reasonable, separate and apart from actually making a change that would benefit the disabled employee? Let's say you've looked at all the things. I've looked at. I mean,
if the alternative is that employee's not able to do his job as he was hired to do, then you've got to make a change, right?
Well, but let's say you've looked at some of these factors. You've looked at modifying the job in terms of job restructuring, or changing the hours, or finding another position, or acquiring or modifying equipment or devices, or modifying your supervisory methods, providing the employee additional training, permitting an employee to work from his or her home. Let's say you've looked at all of those things, and there are others besides those I've just named. Let's say you've looked at them, and you're still concerned as to whether or not a reasonable accommodation can be made. What would cause you to say, in spite of those things, I'm not sure I can actually give you this accommodation? Well,
if it doesn't.
Well, the nature and the cost of the accommodation, right? It might cost the company too much money to allow you to do that sort of, to make that sort of accommodation. Now, chances are, with all of these factors involved, you're probably going to be able to find some accommodation. But if you can't find some of these things that I've mentioned, and to do otherwise would cost your company so much money that it couldn't function properly, you're not required to give an accommodation. In other words, the overall financial resources of the facilities that you own, and the effect of the accommodation would have on the operations of your company would not only affect your company, but other employees as well. So you're not required to put your company at risk and affect the overall resources of the employment situation by giving an accommodation. You're not required to risk your company. Let's say you have to transfer somebody out of their position, and the geographic separateness between where this person would have to work from home or where your company is would make it inappropriate for them to keep in touch with customers on a regular basis. Well, you wouldn't be required to give an accommodation because that would affect your customer base and therefore affect your business. So if we recap this, we have to understand that there is an interactive process that's required by the employer and the employee. Number two, you have to look at various aspects of your particular job in relation to that employee who is disabled to see if you can accommodate that employee, but you're not required to give an accommodation. In other words, there is no reasonable accommodation if it's going to affect the overall structure and financial well-being of your company. Because remember, we're not talking about just an accommodation here. We're talking about a reasonable accommodation. And that means that it's got to be reasonable for the employee, but it's also got to be reasonable for the employer. So
Bill, before you recap, Okay, so you've done your due diligence, and it's going to cost way too much to make this accommodation. So at what point you're at that point you're left with, okay, I can't help you any further because it's going to be way too expensive to make any changes. Then what choice do you have as an employer? I mean,
Well,
what's the next step?
The choice you would have as an employer would be threefold, right? One, you make an accommodation. Two, you can't make an accommodation and you terminate the employee. Or three, you can't make an accommodation and you lay off the employee. Now, what you would try to do in the second two scenarios where you terminate or lay off, you want to try to get them to sign a document, which would be a release, in effect, a release, where they would promise not to sue you for any issue in exchange for some sort of separation pay. That's what I would probably do. Unless you just had a really good employee who just happened to say, yeah, I know I can't perform this job anymore. I want to thank you for all the years so you let me work here, and I'll have to find something else. I mean, those good people do exist in our society still today. But unless you had an issue like that, you'd probably want them to get sign a separation agreement, which would include a waiver of any potential litigation down the line. Because every step in this process, this interactive process, is a potential minefield for litigation, whether the employer knew the employee needed an accommodation, whether the employer or the employee sufficiently engaged in the interactive process in good faith, whether the provided accommodations were reasonable. All of these things are issues of fact that can cause litigation. Let me repeat that. I can't emphasize this enough, because this really covers everything we just talked about. If you have engaged sufficiently in the interactive process with the employee to determine if an accommodation is needed, number one. Two, if you've determined whether the accommodation is reasonable, should you be able to attain one, and whether you've done all this in good faith, all of these are factual issues. There's no black or white. It's all a gray area. You have to do the best you can. You have to document it with a witness present when you have discussions with these employees, and you have to write down everything that would go in the file on that employee, so you have a basis to protect yourself down the line should a lawsuit come your way. So that's it in a nutshell, Rick. I hope people got some benefit out of this. This was, by the way, I believe an article that I took, that I did in the last Bottled Business Sense newsletter that came out either last month or the month before. So I would urge them to look in either the July or the August Bottled Business Sense newsletter. And under the employment section, you should be able to find this disability accommodation article. And that would be at www.bottledbusinesssense.com. We also have bottledbusinesssenseshow.com, but the newsletter is bottledbusinesssense.com.
Awesome. Well, Bill, thank you very much for that information. As always, very thorough, very to the point, and very concise. So I want to thank you that with our viewership out there today. Folks, if you find yourself in this situation, don't hesitate to reach out to Bill. He's very responsive no matter where he is in the world. And so his contact information is located below this video. But Bill, why don't you share your phone information for our viewers out there?
Sure. Really important stuff. This really is. I can't emphasize it enough. Anyway, Bill at WFBLegalConsulting.com is my email. Of course, the website is WFBLegalConsulting.com. Phone numbers, both 949 area code. First one is 413-6535, and the other one is 698-6222. And we'll look forward to next week's show, Rick, and another presentation that'll help hopefully all of our business owners and employees continue to function in a profitable way. I mean, that's what we're here for, to have a business profit and to protect the business as well.
Awesome. Well, thank you everyone for joining us in today's episode. Please reach out to Bill if you have any questions in regard to this topic today. Feel free to also go back to bottlebusinessshow.com for any previous episodes, and we will sign off with that and that chirping bird in the background. And
that's the minor bird. Don't make fun of the minor birds.
Yeah.
Okay.
And we will see everyone again back here at 10 o'clock on Tuesday here on the Bottle Business Sense Show. So with that, we'll sign off. I'll see everybody next week. And Bill, take care. We'll see you again next week.
Yep. Take care, everybody. Have a great week. Bye-bye.